Good morning, everyone. I would like to thank you for joining us today for what we hope you will find to be an interesting and informative webinar on considerations for potential defendants in class actions in Thailand. My name is Eric Meyer, and I am with the Bangkok office of Tilleke Gibbins. So before introducing my co-presenters, I just want to tell you a little bit about my background, which is before moving to Thailand, I practiced product liability law in the United States. And most of this was working on tobacco cases, but I also worked on pharmaceutical and medical device cases. And in all of those industries, a lot of that work involved class actions. So class actions are something that I had experience with from my practice in the United States, and something, because of that background, I continued to follow with interest after I moved to Thailand. And so while I'm familiar with class actions in the United States, my colleagues and co-presenters are the real experts on the topic of class actions in Thailand, and I'm happy to introduce them to you now. First is Anyamani Yimsaard. Anyamani is an associate in the Dispute Resolution Department in the Bangkok office of Tilleke Gibbins. In her practice, she handles a wide range of litigation in both civil and criminal matters, including, in addition to class actions, money laundering, product liability, customs, and white-collar crime disputes. She also fairly recently took some time away from Tilleke Gibbins to study for her LLM in transnational arbitration and dispute settlement from Sciences Po Law School in Paris. And since returning to Tilleke, she's continued to work on arbitrations as well, most recently on an ICC arbitration for one of our clients. My second colleague and co-presenter is Suruswadee Jaimsuwan, counsel in the Dispute Resolution Department of Tilleke Gibbins. Suruswadee brings a unique background and experience to her role as counsel here, which is something her clients particularly appreciate, as she helps them navigate case strategies in complex criminal and commercial litigation cases. Earlier in her legal career, Suruswadee worked for the Ministry of Labor, where she focused on the drafting of legislation. After that, and before coming to Tilleke, she served as a judge for a number of years, presiding over a wide range of both criminal and civil cases. So this background provides her with not only extensive knowledge of Thai law and court procedure, but also with special insight into how Thai courts apply that law and carry out those procedures, all of which is greatly appreciated by her clients. Next slide, please. So here's a brief overview of today's webinar. First, I will give an overview of some of the key features of class actions and the Thai class action law, after which I will turn it over to my co-presenters to provide much more detail on the main topic for today, strategies and considerations for potential defendants in class action, with those subtopics that you can see there. And then at the end, we'll have some time for a Q&A. Next slide, please. So the Thai class action law is actually a set of amendments to the Thai Civil Procedure Code. The law originally started out as a bill proposed by the Securities and Exchange Commission to provide remedies to investors who had suffered violations of the Securities and Exchange Act. But while it was being reviewed by the Office of the Council of State, others realized that the relief that class actions could provide could be beneficial to other classes of plaintiffs as well, not just shareholders. As the law continued to be developed, the U.S. Agency for International Development became involved, and U.S. lawyers shared their experiences with class actions under U.S. Federal Rule of Civil Procedure 23. This is the federal U.S. class action rule, and the Thai law is based, at least in part, on this rule. So after a number of years of developing and drafting the law, the new law was finally passed and went into effect in December of 2015. Next slide, please. So what is a class action? Well, a class action is a case involving multiple plaintiffs where, rather than proceeding with all of those multiple plaintiffs as parties in the case, there's a representative plaintiff or a few representative plaintiffs standing in for all the other class members who are unnamed and who are not parties in the proceedings themselves. And so what is that class and who are those members? Well, that class is made up of individuals who have similar claims or suffered similar damages against the same defendant or defendants. So maybe they bought the same product manufactured by the same defendant and suffered the same damages from the product. Or maybe they live near the same location where there's a factory that's polluting the environment or contaminating the groundwater and harming their crops. Whatever that class is, however it's defined, the members of that class will be bound by the judgment in that class action unless they opted out, meaning that unless they chose not to be a member of the class, even though they otherwise qualified. And we'll discuss that more later as well. Next slide, please. So in looking at the requirements for a class action under the US rule, that rule provides that one or more members of a class can sue on behalf of others only where certain requirements have been met. And those initial requirements are here on the screen. First is numerosity, the number of the parties. The parties must be so numerous that joinder in a single non-class action case is impractical. The next one is commonality. As we've got one plaintiff or a few plaintiffs representing hundreds or potentially thousands of class members, it's important that there are questions of law or fact that are common to all of those class members. And next is typicality. Not only must there be common questions of law or fact, but the claims of the representative plaintiffs must be typical of the claims of the class. So in other words, are the plaintiff's claims generally the same as those of the other class members, or is there something unique about the plaintiff's claims? Or from the defense side, is the named plaintiff subject to or not subject to a unique defense that applies to the other class members? As a defendant, if you have a defense against the unnamed class members, but not against the named plaintiff, we would argue that plaintiff is not typical because the defense that we can assert against these other unnamed class members, we can't assert against the named plaintiff. So that's the typicality concern. And finally, adequacy of representation. Again, these plaintiffs are representing potentially hundreds or thousands of class members. So we have to make sure that they're able to do that fairly and adequately to protect the interest of the other members of the class. In other words, there's no conflict with the named plaintiff and the unnamed class members. Next slide, please. So if these requirements are met, US Rule 23 also provides some additional requirements that must be met before a class action proceed. And I won't cover all those here. I will just mention one that's particularly common in cases involving monetary damages, which is most cases. And it's also relevant to the Thai class action law. And that is in addition to the requirements that we saw on that last slide. Rule 23 also requires that the court find the following: predominance and superiority. Predominance is that those common questions of law or fact that we just talked about predominate over questions affecting only individual members. There will always be questions that affect individual members. But in looking at this, the court has to determine that it's the common questions that are the most important in the case. And then finally, superiority. Even if everything else is met, the court still must be satisfied that class action is still the way to go. The class action is still superior to any other potential methods of proceeding with this multi-plaintiff case. Next slide, please. So that's just a bit of background on the United States law on which the Thai law is at least in part based. And so when we look at the Thai law, this is a section of the Thai law, you can see that some of those same considerations are written into the Thai law: the commonality, numerosity, superiority, and typicality or adequacy of the representation. So some of those same concepts that we just saw from the US law are specifically written into the Thai law. Next slide, please. And I would also like to just very briefly highlight some of the other features of the Thai class action law that my colleagues will be speaking about in more detail. Now there's certainly many other features we could highlight here, but these on the screen are ones that my colleagues will be speaking about shortly. First is the notification by publication. If I'm going to be a member of this class, I need to be aware of the fact that I'm a member of the class. So the potential class members have to be notified by publication. In the United States or other mass media. In the United States, I will sometimes receive a letter in the mail telling me that I'm a potential class member, or more recently, those announcements come by email. Under the Thai law, they mention newspaper publication, as well as mass media or any other means that the court deems fit. And the reason notification is important ties in with this second point, is the opt-out provision. If you are a member of the class, you are a member of that class unless you opt out. And you will be bound by that decision, whatever the decision the court makes in that class. So that notification comes with explanation of the class and your rights within that class, including the right to opt out. For whatever reason, if you decide not to be a member of that class, you can opt out by a specific deadline and you will not be bound by the outcome of those proceedings. It also means you won't get the benefit of those proceedings if they go in the plaintiff's favor, but that's the opt-out provision. Another feature is the fact that during the proceedings, the court has the power to find additional facts, including taking evidence other than what the parties presented. If the court determines that it needs more information on causation or on damages or on the other things it needs to find in connection with class certification, it can do that on its own through other evidence, other experts like that. And finally, a feature that is unique to the Thai class action law and certainly very different from what we have in the United States is there is an attorney reward of up to 30% of awarded damages for successful plaintiffs. Now, this is in addition to fees. Attorney fees are available too, just like in other civil cases in Thailand. And like in those cases, those are typically nominal. But this is an additional reward for a plaintiff who is successful, plaintiff's attorneys who are successful. They can get up to 30% of the awarded damages, and that's up to the court's discretion. But it's up to 30%, and that's an additional 30%. It's not 30% of the money awarded to the plaintiffs. It's 30% on top of that amount, which makes it different to the system in the United States, where the attorneys would typically take from the plaintiffs whatever amount was awarded. This is on top of that. And Kun Anyamani will speak further on this near the end of the presentation today. Next slide, please. I would like to refer just to one final section of the Thai class action law, and that's section 222/8, which specifically mentions certain types of cases that are appropriate for handling under Thailand's class action law when there are a large number of class members. And at this point, I would just like to mention a few examples of cases that we have seen under a couple of these categories over the past 6 years since the enactment of the Thai law. Now, if you've been following class actions in Thailand closely, you're probably familiar with the ones I'm about to mention. Even if you've not been following them closely, there's a chance you've heard about them because they've been widely reported, or they were widely reported at the time in the Thai and English language press. Next slide, please. The first one is Wax Garbage Recycling Center. And this was a case brought against an industrial waste recycling operator in Ratburi province. The plaintiffs were residents of the village who lived near the plant, and they claimed that the plant was contaminating the land and water around their village, causing personal injury, property damage, and agricultural business interruption losses. And while this was not the first class action filed after the enactment of the new law in 2015, we believe, or to our knowledge, it's the first class action that was certified. And in this context, certified means that the court agreed with the plaintiffs that the case could proceed as a class action. And the case was filed in 2017. It was certified in February of 2018 and reached a judgment in 2020. And in that class, there were approximately 1,000 people, and their initial claim was approximately 500 million baht. And while they were not awarded that full amount, the court did award, the court awarded in their favor, not the full amount, but they were awarded medical and related expenses, health damage, and property damage. And that depended on the nature and extent of their injuries. But just to give one example, for the medical and related expenses, that ranged from somewhere between 15,000 to 45,000 baht per plaintiff. Now, while that in itself, relatively speaking, is not a large amount for an award in a civil case, multiplied by 1,000 plaintiffs, that number becomes very significant for the defendant. And in that case, the attorneys were awarded 100,000 in fees, 820,000 in expenses, and that reward I just mentioned, 170,000 baht is the reward. Next slide, please. Another case that received quite a bit of attention at the time and continues to for some other reasons is Aker Resources. This is the Chatri gold mine in Pichet and Phetchabun provinces. This case is still ongoing. We don't have a result, but the class has been certified. It was certified as a class of approximately 300 plaintiffs seeking nearly 500 million baht in damages for, again, leakage or pollutants coming from the mine that was causing negative health impacts and environmental damage. The next slide, please. And finally, this was another class action which received quite a bit of press at the time, because I believe this was the first or one of the first class actions to reach a judgment. And this was a group of car owners alleging some problems with the transmission in a certain model of cars that they had purchased. And they brought a case against the car manufacturer, approximately 300 members of this class. And the court found in their favor. The court awarded approximately 23 million baht. That was anywhere from 20 to 200,000 per plaintiff, plus interest. And in that case, the plaintiff's attorneys were awarded 150,000 baht as a fee for bringing the case. And they also received a further 800,000 as a reward for winning the case. So while that's certainly not insignificant, 800,000 baht as a reward, it's still not close to the 30% that the court could have awarded. It's closer to 3.5% of the total award to the plaintiffs. Next slide, please. So those are just a very few examples of some of the class actions that we have seen in the past 6 years since the enactment of the law. And there have certainly been a number of others, but so far at least, we haven't seen the large numbers of class actions being filed that some people were anticipating after the law was enacted. And from a defendant's perspective, that's certainly a good thing. But should your company find itself as a defendant in a class action? Or should one of the other companies in your industry be the subject of a class action in Thailand? You may be wondering exactly how this process works, or what happens next, or how do I get out of this? And it is at this point that I will turn it over to my colleagues to discuss further about the next steps and potential options should you find yourself as a defendant in a class action in Thailand. And with that, I will turn it over to Kun Anyamani.
Thank you, Kun Tilleke, and good morning to you all again. I'm Anyamani, an associate from Dispute Resolution Department at Tilleke Gibbins. From Kun introduction, I will walk you through an essential step that potential defendants in class action proceeding will need to go through or should be mindful of. Can I have the next slide, please? So under the class action law, the defendant requires to file two important submissions, which are the first, an objection against the application for class action proceedings, which will need to be filed within 15 days after the copies of the complaints and petition of class proceeding are served. This objection is very important as it will set direction whether the proceeding will continue as the class action proceeding or as an ordinary case. For the second one, upon the court order on the application for class certification, whether granting or not granting, the time frame for submitting an answer will start ticking. The defendant requires to file an answer within 1 month after the summons is served. However, this deadline of submission can be extended by the request filed to the court. Can I have the next slide, please? So upon the submissions that in previous slide, each submission will follow by this hearing that will be conducted in two parts. The first part of the hearing is the important one, which is the examination of the application of the class action proceeding itself. Upon the order granting the case to be proceeded as class action proceeding or not, then the second part of the hearing will be commenced. The second part will be the hearing for adjudication, which the court will fix the date for first appearance, for the date of taking evidence, and the rest of the witness examination, which I will walk you through again at the end of this presentation. For the next slides, I will explain further first about an examination of application for class proceeding, which is a very crucial stage that will set the direction and strategy for the overall of the case for the defendants. Can I have the next slide, please? As I mentioned before, the examination for application of class proceeding is very important to the case strategy, since it will set the whole scenarios for the case. Any potential defendants therefore should carefully present their oppositions. For the hearings for class proceeding, not only the parties will have a chance to present its own witness or evidence. The court will take a very proactive role in fixing the evidence that the party will have to present at the first phase, or may consider to request the party to present any additional witness or evidence or even the expert to be present in the hearing. Or the court may decide to conduct additional examination on any issues by their own. After the hearing is concluded, the court will consider whether to grant or not to grant the permission to conduct the case as class proceedings. Can I have the next slide, please? So the permissions to class action proceeding will be granted if the court is satisfied on these following elements, which has been touched upon by Kun Eric at the beginning already, which are the commonalities, numerosities, superiority, and typicalities. Next slide, please. After the consideration on such elements, the court will order whether to grant or not to grant the class proceeding. So if granted, the court may then define the specific scope of class and may also specify the circumstance of person that not include in the class as well. But if not granting, the proceeding will be conducted as an ordinary case. Before going further, the court will order the plaintiff to revise the complaint to be proceed as an ordinary case, and the rest of the class member therefore will need to initiate their own claims separately. For this order of classification, parties can file an appeal against the court order on class proceeding within 7 days from the date that the court issues an order. Next slide, please. So to give you a clear view of how the court considered the application for class proceeding, I will recap the recent proceeding where the court has not granted the orders for class proceedings. So this is the case of that filed by the consumer against a major mobile service providers in the dispute related to overcharged mobile service fee. The court has rendered it ordered for not granting the case to continue as class proceeding based on the following reasons. First, on the damage. The court ruled that the calculation principle raised by the plaintiff applied to the class member are different. The court has provided further that the court has to decide the case in respect to each individual mobile phone users, such as whether there was a breach of contract or any wrongful act occurred to each one or not. And if so, how much damage and compensation would be for each individual. And such issues shall be defended by the mobile service providers, not the consumers. Therefore, the user could easily file the complaint individually, showing their own circumstances. So the court has provided the witness examination for such cases are not complex or complicated for parties. And the class action proceeding will only partially facilitate the submission of the complaint and some part of the witness examination, but not the whole. So the court rendered that the class proceeding would not clearly be fairer or more efficient than the ordinary proceedings. We will say that the court has considered both elements on the qualification of the class member, whether on the circumstance of the cases, the damage, and its calculation method. And importantly, the court will also consider on the procedural elements, whether the class proceeding will be fairer and more efficient to the court and to the parties or not. Next slide, please. So before going to other stage of the proceeding, let me quickly summarize the issue regarding the objection once again. Upon receiving the copies of the complaint and application for class proceeding, the defendant will have to file an objection within 15 days or possibly file a request for extensions. The key objective for this objection is to prevent the case to proceed further as the class proceeding. So the defendant might have to possibly defend on these following issues. For example, on the qualification of class member, for instance, the defendant might argue that the class of persons are not from the same situations or suffer from the same circumstances, or the plaintiff does not provide adequate qualification of class member. Or the defendant also can defend that the method of calculation and payment, for example, the defendant might object that the group member has suffered from different types of damage, or the plaintiff does not provide adequately clear calculation principle or method of payments. And also the defendant can also rely on the issues of the procedural efficiency as well, as we seen from the mobile charges case that I've presented to you recently. And after filing this objection, the court will fix the schedule for the examination of the application of class proceeding, which the party will have opportunity to present a witness by its own initiative or by order of the court, and the court will take a very proactive role in hearing the case. Next slide, please. So apart from the hearing for examination or application for class proceeding, the hearing for adjudication itself in class proceeding also has some distinct features that worth mentioning today, which I will briefly walk through these slides. So the proceeding will begin with the first appearance of the parties. The court will fix the date of the first appearance for all parties to meet and conclude the evidence and witness. However, 15 days before that first experience, the party will need to submit its list of evidence and copies to the opposing parties. On the first appearance hearings, the court will consider the complaint, answer, and might also question the parties on allegation and defenses. Some of the facts might be as well settled by the party on this hearing. The court will then determine the remaining issues in the dispute and set the date for taking of evidence, where the party will have a chance to inspect the evidence submitting by opposing parties. So the taking of evidence, or similarly to discovery sessions, will be fixed as approximately 10 days after this first appearance hearing. The court will also use this first appearance hearing to fix other housekeeping issues, like fix the date and details for proceeding and witness examination. For the class action proceeding, the court will continue to have a very proactive role in controlling the proceeding. The court can also has authority to appoint the class action officer, who will collect the information and inquire essential evidence and witness or expert and prepare a report for the court as a stage of review of the evidence before the hearings. However, the party can examine such report and is able to object. The court might as well order the class action officer to facilitate or oversee the proceeding for the court. In addition to parties' evidence, witness, and class officer reports, the court has power to find additional facts by its own discretion at any stage for purpose of adjudication or the interest of justice. The court can do the variant of examination from take oral witnesses, documentary evidence, or can request other witness other than evidence of the parties, including opinion from the expert, to be presented to the court. However, again, this evidence brought into the case by either from the court discretion or class action officer must be acknowledged by all the parties, and the parties are able to object such evidence or such reports. So apart from party submissions, witnesses, and evidence, the party in class proceeding, especially defendants, need to closely examine all materials in the court case file and object if needed in order to fully defend its cases. Now you may have some picture of how proceeding will look like. I will now give the floor to Kun Suruswadee, who will take you through the class action procedural law and possible channel to stop the case from proceeding either by cause or by party initiative. So,
thank you, Anyamani, for the overview on what is needed to be done after receiving a class action related subpoena from the court. Also, your comments on how to defend class action petitions put forward by a plaintiff. In my presentation here, you will see what Eric had mentioned, the very key features of class action law. You'll see how those criteria, public notification, opting out, and how the court takes additional facts on its own discretion could play an important role in a case, especially when your aim is to stop the case from proceeding, especially when you're a defendant. Next slide, please. I divided my presentation into two parts according to the two categories means to stop the case from proceeding. First is by cause, and the second is by the parties. My focus here is on how to stop cases from ending with a trial and with the court rendering a judgment. So let's leave rebutting the merit of the case for the moment here. Next slide, please. To understand the workings of class action law, we must first understand that class action law is a special procedural law. Where class action law is silent, other more general procedural rule will apply. Please see section 222/4 here. You can see that when any part not specifically stipulated in this chapter, ordinary procedures shall be applicable, okay? So next slide, please. To simplify that very concept, I made this slide to assist you throughout my presentation. You can see from the outer circle, this means ordinary procedural law provides as a general law, a basic law. Other specialized law like consumer procedure law is in the inner circle, and the bright orange one is class action law. I put an arrow on the left to illustrate that it is not static and the rule can change, and this would depend on the workings of the law and what step we're in to the case. Later in this presentation, you will see this graphic on the left-hand side. I'll be putting an arrow on to indicate what type of procedural law I'm talking about in each step. Let's say that this is somehow our map to understanding class action procedural law throughout my presentation. Next slide, please. Let's start with part one. How can a case stop from proceeding by cause? Next slide, please. Let's not forget, we're going to use this graphic throughout. Next slide, please. First one, by the court. Look at section 222/19, and you can see that I have an arrow on the bright orange part, class action procedural law. It's where the court ends the class action proceeding and proceeds with the case as an ordinary case. The court would exercise this power if it sees that the class action proceeding is not adequately protecting or benefiting the class members, or is no longer necessary to conduct class proceedings, or the plaintiff's lawyer is unable to carry out those proceedings to adequately and fairly protect the rights of all members. And the named plaintiff and class members fail to replace this particular lawyer. Okay, so this is part one, ending by the court. Next slide, please. Second one is section 222/25 and 26. As we already know that the named plaintiff is the class's representative and has many responsibilities throughout the proceedings, it is necessary to have that named plaintiff to run the show. Under these circumstances listed here, the court is required to replace the named plaintiff. However, failure to replace a named plaintiff would lead to canceling the class action proceedings. The case would then proceed as an ordinary case. Next slide, please. So you can see that by /26 here, the court will have to order to cancel the class proceedings and shall proceed with the ordinary proceedings. Next slide, please. Thirdly, this, if a member does not opt out from class action proceedings in time, such member cannot file a complaint in parallel with the class action case. In short, any court case filed beforehand would have to be disposed. Okay, next slide, please. This last graphic would help you understand all three. On the left is the first two that ends the class action proceeding and proceed as an ordinary case, which is because of the court order under section 222/19 and /26. And on the right-hand side, you can see the last portion that I just mentioned just now, that other cases by class members cannot proceed. It has to end. It can only be one case in the proceedings. None of unless those class members opt out from the process. So that's how other cases be stopped from proceeding, because it cannot be in parallel with the class action case. Next slide, please. Now, coming to part two. How can a case stop from proceeding by the party's action? Again, next slide, please. This graphic will be used again. Next slide, please. Now for ordinary cases, Section 20 is mentioned here. The court has the power to mediate. It can choose not to exercise that power. However, for class action cases, you can see in Section 222/20, the court is required to conduct mediation. You can see that there's a differences in the language of the two sections. You can see the arrow here. It says that Section 20 is for ordinary cases and Section 222/20 is for class action procedural law. So we are forced to talk. Next slide, please. Negotiation could be beneficial for all of us, okay? The results of such negotiation could be, one, the plaintiff agreeing to withdraw the case, secondly, to reach a compromise agreement, and thirdly, the parties agree to proceed the case through arbitration. Next slide, please. Now, what the law says in regard for ordinary cases if the plaintiff files a petition to withdraw the case. Now, in normal cases, the court usually grants it. There is no requirement to notify other members or the defendant, of course, unless the defendant had already submitted his answer to the court. In this case, the court would ask the defendant whether he opposed to the withdrawal or not. But for class action cases, next slide, please. If the class is already notified, the court cannot grant that petition without providing class members the chance to oppose to that petition. It is required to notify all members of the withdrawal petition, allowing at least 45 days for other members to file an objection. Okay, next slide, please. If the negotiation or the mediation process was so successful, the parties would be able to reach an agreement. In normal cases, the court would only check if the content of the compromise agreement is contrary to Thai law of public peace. Then the court would sign as witness and grant the parties with a consent judgment. For class action cases, next slide, please. After the time to opt out from class action has lapsed, the court is required to notify the members before signing the contract off. This is to allow other members to opt out or to object the draft agreement. The reason behind this is that once the compromise agreement passes this process, it was also bound other members who had not opted out. Next slide, please. Last but not least, parties may agree to have the case arbitrated. Again, in ordinary cases, this is left for the parties to decide. However, in class action cases, the court has this active role, next slide please, same as the two incidents above, to make sure that such proceedings is beneficial for all members. So the similar rule of executing a compromise agreement is also applied here. The members are needed to be notified and the court would have to inquire. Again, one of the key features here is that it is a potential that the court will take additional facts on its own discretion where necessary. Next slide, please. What does the court take into account in deciding whether to grant these withdrawals, agreements on the merit, and to have the case arbitrated is stipulated in section 222/32 here. The court shall take into account many things, including the necessity to continue as class proceedings, protection or interest of class members, difficulty or convenience in continuing class proceedings, fairness and efficiency in continuing class proceedings, number of objecting class members, the defendant's ability to pay compensation in the event of agreement or settlement of the merit of the case, and most importantly, whether or not the agreement or settlement on the merit of case between the parties is fair and beneficial to class members. So the court is acting somewhat on behalf of other class members who had not opted out as well. So next slide, please. For part 2, you can see that class action cases could end by agreement or withdrawal by the named plaintiffs, and the case could simply stop proceeding in court, but then change to arbitration as a class. On the left-hand side, you can see that the class action case just ends with a class agreement or class withdrawal. And on the right-hand side, you can see that it ends as being a trial in court, but continues as arbitrated cases. So those are the ways class action cases can end in different scenarios. Nonetheless, the concern that all defendants should have in mind is the legal fees. And on this part, I would like to invite Kun Anyamani to elaborate on this issue for us. Please, Kun Anyamani, the floor is yours.
Good morning again. Now we nearly come to the end of today's presentation, and I will briefly discuss about another key features of the class action law, which is the lawyer rewards. Speaking of the lawyer reward, we are not referring to a lawyer fees, not a court cost or award on the merits, but the lawyer reward is an amount of money that the court can award on that discretions up to 30% of the amount of the total award that will be paid to the defendants, to the plaintiff and class members. So the court will consider the hardship of the case, time period, and work performed by the plaintiff, and then the plaintiff lawyer will become one of the creditors by the virtue of the awards. So now you will see that the case, as the case continues as class action proceeding, the proceeding will be more complex. The amount of the award could be very high, and also will be topped up with possible up to 30% rewards to the plaintiff lawyers. So as the defendants, it might be quite crucial to try to stop the case proceed from class proceeding at the first stage. So we will have the questions and answers sessions now. I will give the floor back to Kun Meyer.
Thank you, Kun Anyamani. And that leads us right into your last slide, leads us right into the questions that we've been asked by some of our participants today. And I'll just look at the first one that we have in the question and answer, and there's also one we'll get to next in the chat. But the first one is just wondering how to calculate the reward rather than the legal fee, or whether it depends on any agreement or satisfaction of the plaintiff. So could one of you please speak a little bit more about how that reward is calculated?
Yes, I can assist on this one, Eric, and if you have any comments.
Sorry, Suruswadee, you're on mute, or we can't hear you.
Can you hear me now?
Yes.
Okay, great.
Sorry.
So to answer this question, can we go back to slide 37 or 36 of mine, the one that we have this chart of ending the court proceedings? This is fine. This one is fine. You can see the chart on the left-hand side. And my presentation, I've already mentioned that I will leave the judgment and the trial process on the side. So imagine that we have another option, the fourth option of having a judgment, a trial and a judgment, right? So how to calculate this reward that Kun Anyamani mentioned? In Thai language, this code used the word Ngan Rangwan, which is translated to the word reward. But in the detail of the code, it says here in section 222/37 that when the court is issues a judgment ordering the defendant to perform for this purpose of the expenses, the reward. For this purpose, after the trial is over, the plaintiff's lawyer shall submit the list of such expenses to the court and send a copy to the defendant. So basically, the court will look at the real expenses, the time that it was used over the case, and what work has that particular lawyer done throughout the case. So there are many ifs here. This section will be activated if the court is required to give a judgment on the merit of the case. So if the court if the case ends in that way, the fees would be determined with this kind of rule, the criteria, expenses, time, work done. And with the ceiling that Kun Anyamani mentioned is that the 30%, right? So that rule will apply. But if the case ends otherwise, like with an agreement or outside agreement, like if the case was withdrawal, then the fees or that will be upon agreement rather than the judge having to stipulate in their judgment of how much the fees would be. So that's a different, so to tackle that question, one must think first, well, how the case is ending. So I think on that one, I think that should be answering all of that.
And then another question that just popped up in the Q&A box asks, who has to pay the 30% reward, the defendants or the plaintiff? And it's the first of all, it's we say 30% because that's the ceiling. It won't necessarily, as we've just discussed, it won't necessarily be 30%. And the two examples that I gave, in one of those examples, it was 3.5%, and in the other example, it was certainly less than 30%. And so it's just wanted to clarify at first that it won't necessarily be 30%, but it will be paid by the defendants, and it will if the plaintiff wins the case, it will be the defendants paying that award, whatever the amount is, on top of whatever they paid to the plaintiffs. And that's, I mentioned earlier in my part of the presentation, that that's also a feature that distinguishes it from the United States system, where in the United States, if the plaintiff wins $1 million and the attorneys get 25% of that, then the plaintiffs only get $750,000 because their attorneys are taking $250,000. But it's not like that here. It's here that whatever that reward is on top of whatever that the defendants must pay to the plaintiff. And then the second part of that question is the rationale for including this reward. I'll let my colleagues answer this. I think part of the rationale would at least be to provide some encouragement for plaintiffs plaintiffs' attorneys to bring these cases. So it's not because they can be complex, a lot of work with the number of plaintiffs involved, the number of issues involved. And as we know, the fees that are typically awarded in your average civil case are fairly nominal. Even in the two examples that I gave, the lawyer fees that were awarded were around 150,000 baht. So I think, and again, I will defer to my colleagues who are the experts on this, but I think that was the rationale, was to give a little bit of at least some incentives to plaintiffs' attorneys to take on these challenging, difficult types of cases that class actions often are.
I really like the word "some encouragement" that Eric just used there, because yes, there is an encouragement in section 222/37. The last part of that section says that it shall be deemed that the plaintiff's lawyer is a judgment creditor and the defendant is a judgment debtor in part of the reward. So that's an encouragement. But when it's in practice, you can see from Eric's presentation, from the beginning of the presentation, that the actual money that the court grant the lawyers is not that high, especially compared to the ones in America. And the nominal ones that Eric mentioned is, I think, in ordinary cases, it's usually nominal. So the court in Thailand is not used to providing big sums of money on this part. This is my comment, but it could change under the circumstances and the case fact. So Kun Anyamani, would you like to add on this topic?
I think you have covered all of the answer that I might answering, but I think will be worth mentioning about the expenses that can be quite substantial as well. As we see in the vast garbage cases, the plaintiff lawyers can also submit their reports declaring on the expenses they use in the class proceeding, which can be requested to be paid by the defendants as well. So that might be a big sum of money as well.
Sure. And if it's going to be up to the court, I trust that the court will
Yes.
screen that expenses list quite.
Yeah. But as we see from the vast garbage cases, that amount of expense is quite substantive comparing to the rewards.
Right.
And Anyamani, do you know, on that issue of the expenses, do you know if those expenses, I would guess that a lot of those expenses were because they had to have experts involved, or just the nature of the evidence, where you have 1,000 people all claiming different types of damages, not just medical, but like health damage, not just medical expenses, but health damage to property, business interruption losses. I would guess that a lot of those expenses, if not all of those expenses, were addressed to experts.
I believe it's that way as well. I never see the detail of vast garbage reports, but I expect that partly will be on the evidence or investigation of the evidence or witness,
Okay.
and also in inquiring details of the class members itself, because they have like thousands of people and living in up countries.
Right.
So that takes expenses.
Okay. Hey, then on the same topic, we also have a question in the chat box about this, the reward, which is, does this attorney reward imply that attorneys will be less willing to settle out of court? Which is a very good question, very interesting question. My thought on that would be, as a practical matter, perhaps it gives them less of an incentive to settle out of court, but it shouldn't. I mean, they should be interested. They should be interested in what is best for their client. What is the best result for their client? And that should not. I might be a little too idealistic here, but that concern should not be within their consideration as they make the judgment they often make, which is do I settle or do I go to trial? Is this settlement the best I can do for my client or my clients? Or do I take the risk, and do I think my case is strong enough, and do I think I will I can do better with my clients in front of the judge if we get a judgment? So your question's an excellent one, and I think the reality of the situation, it probably does in some circumstances, but it should not. It should it's the attorney's, it's the attorney's duty to get the best result for their client, regardless, whatever that result may be. So I'll turn it over to my colleagues to see if they have any further comments on that.
I agree, and well, there are many lawyers for a person to choose from in the market, right? But think wisely when you choose one, or choose one with integrity, and yes, that would definitely have impact in the outcome, and even with the process, right? Because class action proceeding is quite complex, and what we discovered during our research is that it usually takes a bit of time, right, for the proceedings to go on in court. Sometimes it takes years to decide whether to proceed as a class action case or not. So you can see that the expense and the lawyer, the named plaintiff's lawyer, and the named plaintiff is very crucial to these proceedings. So yes, and the defendant's lawyer will have to definitely take a lot of responsibility into rebutting, not only on the merit of the case, but also on the petition for the case to be determined whether to proceed as a class action or not, like Anyamani mentioned from the beginning, right? So choose wisely. So Eric, back to you. Any further questions?
I don't see any. I don't see any further questions in our chat box. Well, one just popped up asking. regarding the Accra mine case, is the continuation of that case affected by the government's recent decision to allow Accra to resume mining? No, this case had been on hold. It will be interesting to see how that decision affects this case, but this case had been on hold for some time. So that was months before that decision, the case was on hold, but it will be interesting to see how that decision affects the case going forward. And so so if those are all the questions, the last question I would have is just, this was something that was in my initial presentation when I was discussing the requirements of the class action. We talk a lot about numerosity. You have to have, the class has to be big enough. And we see some examples of 300 and 1,000 and more than 1,000 during the presentation. And so I would just like to ask my colleagues in Thailand, is there a number? Is there a minimum number? I will say in the United States, for example, there's no minimum number written in the law. You saw the law, it's the same in Thailand. It just says you have to have enough. You have to have so many that it becomes impractical to do it another way. And there's some cases and some courts in the United States have said 25. 25 is a number you see a lot in the United States in answer to this question. 40 is another number. That's where, somewhere in that range, 25 to 40, where the judges say, you know what, anything less we can probably handle a different way, but around that range is a good range for class action treatment. Other courts in the United States will say, we can't give a number because there's so many factors. It depends on where are the plaintiffs? Are the plaintiffs all living in the same area, or are they spread out over the United States? How complex are their claims? What types of witnesses, what types of evidence? So it's just a lot of courts are, while you see the numbers around 20 or 25 a lot of courts are reluctant to give a minimum. It depends on the case so much. What about, how does that work in Thailand?
So in Thailand, there has not been that many cases in Thailand, but then upon our research, I think we found something around 20-25 to be the minimum as well. But that would depend on the facts of the case, right? If on that case, I believe that the claim was in a high amount, so the number of these people would go to the court and file the complaint themselves were higher. That chance was higher. So the court was reluctant to utilize this class action proceeding in that case. However, my personal opinion is that it should be well above 20, in my opinion, because I think lower than 20, it's still manageable in a court case easily, in my view. But then again, it would depend on the case fact, like Eric mentioned that there are other facts that the court will take into consideration.
Thank you very much. I see that we're about out of time, but I do see we have one more question, another very good question, which is, when we're talking about class actions in Thailand, do all plaintiffs need to be in Thailand? And I believe the answer to that question is no. I believe it will be just like any other civil proceeding in Thailand. They'll have to meet there's nothing special about a class action when it comes to the requirements of where a plaintiff has to be. If they would qualify to bring any other type of case, they would qualify to be a member of a class action in Thailand. That's my understanding, but I will certainly defer to a judge on that answer.
It will depend on the ordinary procedural law, the order circle that I mentioned, the civil procedural code. So that in some cases the plaintiffs are required to be somewhere, but mostly no. It will be where the defendant is and what happened, rather than where the plaintiffs are. So yes, that's my answer in short, because we're running out of time.
Okay.
Well, if I may add from Kun Suruswadee and Kun Eric a bit about the plaintiff that need to be in Thailand or not. Actually, I think we have a recent case about the sugar factories that the plaintiff actually resides out of Thailand, but the court have ordered to certify the class proceeding to cover the plaintiff that are not resides in Thailand as well.
Yeah, so that would be an example of just what Kun Suruswadee is saying, is just that it will just depend on the procedural law that was already in place. So again, excellent question. And with that, our session has come to an end. If you do have additional questions or questions that we did not get to today, please feel free to email our speakers with those. And again, we'd just like to thank you for your time and attention today and attending our webinar.